Protect the flock, we rally in the lion's den. Shield to shield, the storm is thundering. Unleash the roar, let the lions run towards the night until the battle's won.
All right, brothers and sisters, welcome back to a holiday edition of the Lion's Den. We're going to be flying solo today. You get Paul Belanger at the helm here, and we're going to do a little chatting about cease and desist remedies. Now, if you haven't heard, which I'm sure everyone who's around has heard, this is a hot button topic for the Postal Service right now. They are doing everything in their power to shut us down on cease and desist remedies. And there is a method to their madness. They have a strategy. We're going to go over that strategy. I think I can pretty much lay it out for you. And we're also going to talk about what we can do to fight it. Because unfortunately, our national team has not given us an awful lot of direction. And while the Postal Service has this organized attack, we are just letting our stewards hang out to dry and fight these battles on their own. So we're going to take care of that here today. We're going to get you a strategy in place. We're going to give you some references where you can go get this and put it into your grievances. And you're going to be more effective at fighting this in the future for our carriers. So here we go. What is the Postal Service's strategy on cease and desist remedies? Well, if you look at the backlog we have right now, we have 40,000 or so Step B cases that are backlogged. That is a huge, huge number. And I think the backlog of arbitrations has reached, it's either 7,000 or 9,000 cases, equally a huge obstacle to our letter carriers for getting justice. Most of these cases, I'm going to say most of these cases, if not most, a great deal of them are failure to comply with previous decisions, which is where the cease and desist language comes in. So why would we have this many backlog cases? Of course, this tells us something's wrong with our process. And we absolutely are fighting a losing battle if we can't get cases settled at Step B and get precedent-setting language for our carriers in these installations. But what's the strategy? Why are these cases not getting resolved? Well, it's pretty simple, because if the Postal Service does not get cease and desist enforcement language, they win. And on a case-by-case basis, we usually will win these arguments at arbitration. But the problem is we're being subjected to, well, what amounts to blackmail. Because with 40,000 cases backlogged, what happens when a case goes to Step B now? Well, we don't want 40,001 cases backlogged, so there's pressure to settle these cases however we can. And since management is not going to agree to cease and desist, we get this watered down language of abide by or shall comply with. Now, I've had a lot of smart people tell me that abide by and comply with language is the same thing. Don't worry about it. It's all language that's going to enforce the contract. I disagree. And there's actually a great arbitration decision out there that exemplifies why we should not take this language. The decision is from arbitrator Alyssa Samarco. It is from November 27th, 2023. And the number, if you want to reference it, is C36376. Now, this decision should tell you everything you need to know why we need to stay away from abide by and comply with language. The arbitrator concluded in her decision, the term abide by is defined by the Merriam-Webster dictionary as one, to conform, to abide by rules. The term refrain from is defined as to keep oneself from doing, feeling, or indulging in something, and especially from following a passing impulse. And she goes on to state the term does not mean shall never, nor does it mean cease and desist. Cease and desist is a legal term as defined by the Oxford Dictionary as denoting a legal enforceable order from a court or government agency directing someone to stop engaging in a particular activity. The term cease and desist has a specific definition and consequence of which both parties are well aware. They did not use the term of this decision. They negotiated for and used refrain from, which has a less rigid use in the English language, to keep yourself from doing. It is not about absolute preclusion. And this is the part that I really like when she says, when one uses refrain from, one thinks of a self-imposed limitation on future conduct. Clearly, the parties did not agree to the consequences of cease and desist. So if you think about this, a refrain from or abide by decision, if we think of this in a term of what we normally see in our normal everyday life, let's talk about a diet. If you're going to voluntarily refrain from eating a certain kind of food, that's great. That's your choice. But if your doctor says, cease and desist from eating this kind of food or you will die, now that's a lot more powerful. That's the difference between cease and desist and abide by. Abide by, according to this arbitrator, and you're going to see this pulled out by management all the time, abide by language is a voluntary choice on the part of management. Cease and desist is enforceable. Now, oddly enough, in this arbitration decision, C36376, the arbitrator did grant us cease and desist language, but she stated it was as a step above abide by and refrain from. So ever since this decision, maybe a little bit before this decision, we started seeing cases backlogged because management now has it in their mind that they can put another step between the letter carrier and the enforcement of our contractual rights. And this is where we need to fight. Brothers and sisters, we cannot back down. And I'm speaking right now as much to advocates out there and as much to Step B representatives out there. Do not accept, abide by, and refrain from language. Do not put that as a remedy in your grievance decisions. We need to fight for cease and desist language. Now, there's a bunch of arguments that management is going to use in their grievances and at the arbitration table. And you and I, right here, are going to go through what those arguments may be and how we're going to fight them. Because it's my opinion, and I hope you all agree with me out there, that we need to put a specific part of our grievance absolutely arrow sharp on why cease and desist is the appropriate remedy. We need to put a part of our grievance that fights for this. And if we do this often enough, especially if we can get all of our stewards to do this same argument, I mean, management does this, right? Management has these stock arguments that they use all the time against letter carriers. And if you're an advocate, if you've done arbitration cases, you've seen this. You've seen the same arguments time and time again. It's time for us to do that. It's time for us to have an organized plan of attack. Instead of letting our stewards flounder out there, fighting this fight new every single time, let's have an attack plan. Let's go after this the same way every time so that when an arbitrator sees this for the 5th or 6th or 10th or 20th time, they're going to be like, okay, I'm not even going to entertain whether or not cease and desist is an appropriate remedy. It's been decided. So let's look at some of the arguments that management has on why cease and desist is not an appropriate remedy. One of the things you're going to see is management's going to tell you that cease and desist language is something that they can't attain. Cease and desist is telling them to stop doing something, and nobody can guarantee that we're going to stop doing something. Therefore, it's not a proper contractual remedy. This is wrong. I mean, can you imagine if we made this argument? If we were at, say, an arbitration table and a carrier was being disciplined for attendance, and let's say this is the carrier's maybe 5th time around the block, and this is a removal, and we make the argument to the arbitrator, hey, Mr. Arbitrator, you can't fire this person because we can't guarantee that he will be solid in his attendance. He could leave this room and trip on the step and break his leg. He could be out of work for the next 6 months. We can't guarantee good attendance. Therefore, you cannot discipline us. Can you imagine that argument? But that is exactly the argument that management's making. They're telling you that you can't enforce a remedy on them because they can't comply. Well, that's pretty sad. It's pretty sad when they're telling us that they don't have to comply with the contract because they can't guarantee they should. The first thing we really should do is look at the definition of cease and desist, though, right? Cease means to stop doing something, and desist means don't do it anymore. So another argument we hear a lot of times, and we're going to be looking at the JCAM here, so we're going to reference a couple of pages for you, and we are going to have something in writing for you to reference as well, so I'm going to give you that at the end of this episode. But right now, the JCAM on page 17.6, on page 17.6, the JCAM talks about cease and desist language. And this is in reference to a steward's right to information. And it states here, the appropriate remedy in a case where management has unreasonably denied a steward time on the clock is an order or agreement to cease and desist, plus payment to the steward for the time spent processing the grievance off the clock, which should have been paid. Now, I want you to pay attention to this, brothers and sisters. Nowhere here does it say that after the 5th or 6th or 10th time, cease and desist is the appropriate remedy. It does not say that the failure to provide steward time has to be egregious. It just states that it's an appropriate remedy, because management is going to tell you that the violation must be severe, egregious, repeated. You can't get cease and desist the 1st or 5th or 10th time. This has to be the last possible remedy that you can ask for. That's incorrect. Now, another page of the JCAM hits upon this even better. JCAM page 4116. And we are going to talk about these two references to cease and desist in another approach in a second here. But page 4116. Now we're talking about remedies and opting. In those circumstances in which a PTF or CCA worked 40 hours per week during the opting period, an instructional cease and desist resolution would be appropriate. This would also be an appropriate remedy in those circumstances in which a reserve letter carrier or an unassigned letter carrier was denied an opt in violation of Article 41.2b3. Now, this is an important part right here on the same page. In circumstances where the violation is egregious or deliberate, or after local management has received previous instructional resolutions on the same issue, and it appears that a cease and desist remedy is not sufficient to ensure future contract compliance, the parties may wish to consider a further appropriate compensatory remedy. The important thing here, is that they don't say that cease and desist is not appropriate the first time. As a matter of fact, they say that if the violation is egregious or deliberate or repeated, you have to move above cease and desist remedies. So these two sections of the JCAM, page 17.6 and 41.16, you should be citing these and talking about how cease and desist remedies are appropriate. They're mentioned in the JCAM, but more importantly, they're appropriate for the first time a violation is committed to enforce our contract. Now, another thing you're going to get from management, and this is kind of a funny argument, they're going to tell you that since cease and desist language is only mentioned on page 17.6 and on page 41.16, so that's under a steward's right to information and under remedies and opting, that those are the only places that cease and desist are appropriate. They've got something called the inclusion-exclusion doctrine that they're going to cite. And they're going to say that because it doesn't say you can use cease and desist anywhere else, that what this implies is that those are the only places you can use it. So in order to fight this, we're going to go to the very beginning of the JCAM. This is the actual introduction. It doesn't even have a page number here. But in the introduction and preface to the JCAM, I'm going to read a couple of sentences here for you. Some sections of the contract do not have a narrative explanation. No inference should be drawn from the lack of explanatory language. That's in the introduction. So there should be no inference that because cease and desist is not mentioned in other places, that means it's excluded intentionally. We're reading into the JCAM what is not there, and we cannot do that. Now, it goes on to say in the preface, the JCAM is self-explanatory and speaks for itself. It is not intended to, nor does it increase or decrease the rights, responsibilities, or benefits of the parties under the collective bargaining agreement. It neither adds to nor modifies in any respect the current collective bargaining agreement. And it goes on, the JCAM may be introduced in arbitration as dispositive of those issues covered by the manual. If introduced as evidence in arbitration, the document shall speak for itself. Without exception, no testimony shall be permitted in support of the content, background, history, or any other aspect of the JCAM's narrative. So basically, you cannot read something into the JCAM simply because it is not elaborated on. You can't say because it's mentioned in two places that cease and desist is an appropriate remedy, that means something entirely different. That means that no place else is it appropriate. It does not say that. It does not imply that. And you should argue that. That should be one of your arguments as well. Now, another thing we should talk about, and we just kind of touched upon that when we did the whole sick leave comparison or analogy. Both parties in a contract should be given a method of contractual compliance. So both of us, the Postal Service and the union, we should expect compliance with the contract, right? That should be, when we sign the contract, we're both agreeing that we're going to follow the rules. Well, management has something called, you might have heard of this, corrective discipline. And what does that mean? That means that if a carrier violates the contract, that they can correct and progress the discipline until they get contractual compliance. So that's if we violate the contract, management has a tool for contractual compliance. It's corrective and progressive discipline. So what's our tool? What does the union have to enforce contractual compliance? You guessed it. It's cease and desist language. That is our contractual sword and shield. So if the Postal Service has a tool for contractual compliance, we need to argue that our tool is cease and desist remedies. And if the Postal Service comes out and says, well, cease and desist remedies are inappropriate because the union can build upon them. They can increase the remedies higher and higher until we actually comply with the contract. Well, you're damn right. That's the whole idea of contractual compliance, is to find a way to make you comply with the contract. So yes, cease and desist is enforceable, and it may be leading to progressive discipline on the part of management, but they have their own tool for progressive discipline when we violate the contract. We need to make that argument, brothers and sisters. We need to make that part of our grievances if we're looking for contractual compliance with cease and desist remedies. Now, how about this argument? Management says that abide by or refrain from is good enough because they're going to try their best. Well, again, I refer you to arbitration 36376 from arbitrator Samarco. We're not looking for somebody to try. We're looking for somebody to comply. So, and again, if we're at the arbitration table with the sick leave case and this carrier is getting removed, the same carrier we were just talking about, how do you think it would go if we said, Mr. Arbitrator, you don't need to fire this carrier. We promise we're going to try. This carrier is going to try to keep their attendance spotless. They're going to try. Is that good enough? Of course, an arbitrator is not going to accept that. And that's the same reason that we're not going to accept it. Contractual compliance is not a matter of free will. It's a matter of obligation. Now, of course, management's going to love this argument too. Cease and desist language is punitive, and punitive remedies are forbidden under the national agreement. Well, again, brothers and sisters, cease and desist language is our only recourse to enforce our rights under the collective bargaining agreement. Now, there's a great decision out here from arbitrator Jacqueline Drucker from December 23rd, 2021. And this decision, I've got the actual long number here. It's 4G16N 4GC 2107246. And arbitrator Drucker stated in her decision, in more than 30 years of arbitrating thousands of disputes under a vast variety of collective bargaining agreements, this arbitrator has never before been presented with a suggestion that cease and desist orders are not appropriate remedies for contractual breaches. The Postal Service offers no relevant authority for this theory, which, to the extent it can be discerned from the arguments presented at hearing and in the closing brief, is wholly out of step with the concepts of remedy in arbitral law, arbitral tradition, and basic contract law. Indeed, innumerable court decisions from all levels of the judiciary have confirmed arbitration awards that have included cease and desist orders. Now, this is probably at the arbitration level that this next site's going to come into play, but I'm going to bring it to you, and you can include it in your grievance as well to help your advocate out. Something called the Steelworkers Trilogy. There's a Supreme Court decision, United Steelworkers of America versus Enterprise Wheel and Car Corp, 1960. The Supreme Court concluded that an arbitrator is to bring his informed judgment to bear in order to reach a fair solution to a problem. This is especially true when it comes to formulating remedies. There is the need for flexibility in meeting a wide variety of situations. So yes, an arbitrator has the right to form a remedy of their choosing, and cease and desist is one of those remedies. Now, again, I'm going to address this advice to advocates out there. When you are going to arbitration, and the question is whether or not cease and desist is an appropriate remedy, look at the arbitrator that you have presiding over your case. Every single time they have decided a cease and desist remedy is appropriate, you pull that case out. And if you have 500 pages, if you have 5,000 pages of arbitration decisions to give to that arbitrator to remind him that cease and desist is already an appropriate remedy, that's not a question. The question is whether or not it applies here, not whether or not it applies at all. We already know cease and desist remedies are appropriate because you, sir, or you, ma'am, have already decided that 50 times, 100 times. As an advocate, we need to have that case file ready to go right in front of the arbitrator and show them that by their own decisions, cease and desist is fine. Now, I'm going to go back to those two JCAM decisions again. JCAM page 17.6. We were talking about the right to steward time on the clock and how cease and desist is an appropriate remedy here. Again, it never says it's the exclusive remedy for only this situation, but they do say that cease and desist is an appropriate remedy. And also, we just looked at page 4116 for remedies and opting. Cease and desist is an appropriate remedy. So we are going to use the argument that cease and desist is an appropriate remedy as outlined under the JCAM. We're going to specifically say that it's not just for these two situations, but it is already an established remedy. Now, this is an interesting argument I'd like for you to make in your grievance. Anticipate that management is going to tell you that cease and desist remedies are only appropriate in these two situations, page 17.6 and 4116 of the JCAM. I would like you, brothers and sisters, to look at page 4127 of the JCAM. And I'm going to read a section for you here under Article 41.3.I. Carriers shall not finger mail when driving or when walking up and down steps or curbs when crossing streets, or at any time it would create a safety hazard to the carriers or the public. Now, this is the actual expanded explanation underneath. Although there have been no significant Step 4 settlements or arbitration awards interpreting Article 41.3.I, it is wise to bear in mind how arbitrators have generally approached the question of whether employees are justified for refusing to work in a particular place or in a particular fashion because of what the employee believes are unsafe conditions. First, there is the iron rule, stating that an employee must obey now and grieve later. Now, I don't know, a lot of you may not have heard of this, but I'm sure seasoned stewards, Step B representatives out there, and advocates for sure, we've all heard of the iron rule. Obey now and grieve later. You're going to make the argument here that this is the only place in the JCAM that the iron rule appears, is for fingering mail when walking or climbing down stairs or curbs or crossing streets. And yet the iron rule is applied across the board in all kinds of postal situations. Wearing seat belts, driving safely, all kinds of situations where the iron rule states, obey now, grieve later. If a carrier is told to work 13 or 14 or 15 hours and they say no, what does the iron rule say? Obey now and grieve later. We have a new contract provision that says you can walk away. Well, this is going to contradict that, but there are all kinds of other situations that do not have that contract protection, do they? What if a supervisor tells you to go case mail on a rural route? Now, we all know that we can't cross crafts. It's an Article 7 violation, but what do? We obey now, we grieve later, because the iron rule applies everywhere. So we should be making that argument that, Mr. Arbitrator, Mr. Step B representative, the Postal Service wants you to believe that because cease and desist is only mentioned 2 places in the contract or in the JCAM, that those are the only two places that it would apply. And yet the iron rule on page 41-27 of the JCAM is mentioned 1 time in regards to fingering mail, and yet it is applied by the Postal Service in every single situation you can imagine. So why would that be? And it's the same chapter. Chapter 41 is the same chapter as section that we just talked about, 4116, remedies and opting, where cease and desist is discussed as a remedy. So in this same chapter, management's going to make the argument that cease and desist can only be used in this situation, remedies and opting, because it's the only place it's mentioned. But the iron rule of obey now and grieve later, no, that's going to be different. That's going to apply everywhere. So you're going to make that argument in your grievance that doesn't fly. So brothers and sisters, we've got a couple of arguments that we've made here, right? We're going to make sure that the Postal Service knows that when we file a grievance and we put a cease and desist remedy, we're not just going to put the word cease and desist. We're going to explain why it applies. We're going to fight for it. Now, we're going to create a little grievance starter here. It's probably more of a grievance contention, maybe a bullet point. But we're going to talk about the cease and desist arguments, and I'm going to put this up for you. Corey's going to put this up on Formata Arbitration, and I'm also going to put this up on a grievance template site that we're starting to work on called grievancemd.com. If you look under the toy box section, that's a place where we have some tools that carriers and stewards can use to argue grievances. It's going to be up there. There's going to be a short, maybe 3, 4, 5-page section that you should add to every grievance where you're looking for cease and desist language. You add this to your grievance. You're going to talk about why we need cease and desist language, why it's appropriate, and why the arbitrator or Step B rep should not settle for this abide by or comply with language. Now, I'm going to tell you, brothers and sisters, this episode for me was bittersweet because National should have been dealing with this a long time ago. We've got grievance starters out there for all these little things, and yet here we are as a national union with 40,000 backlogged cases. And I'm going to tell you right now, at least 20,000 of those, probably a lot more, are for cease and desist language, are for failure to comply with previous grievance settlements. why haven't we given this to our carriers already? Why haven't we given them the tools they need? Our stewards, our Step B representatives, our advocates. This is going to change. The concerned letter carriers are not going to let us languish as stewards anymore, or Step B representatives or advocates. We are going to be given the tools we need, and this is going to be one of those tools. And you're going to see a lot more of this on the Lions Den as well, where we give you supplemental information to add to your grievances, because there's a lot of areas where it's implied that a steward knows what to do, but we don't. You don't just walk into the union office and know how to write a grievance. So we're going to work through this together, brothers and sisters. I hope you've enjoyed this little journey through cease and desist nonsense that the Postal Service is going to give you. We're going to keep fighting this, and hopefully, when the CLC takes over, this backlog is going to be knocked down because of tools like this we're going to provide to our carriers. So when you hear people online, when you see people post online, well, nobody ever talks about how we're going to get to this point, how we're going to fight these backlogs. This is one of the tools we're going to use. We're going to actually address why the grievances are sitting there and how to resolve them. We don't need these step C decisions where we're getting a penny on the dollar. We're going to fight for everything tooth and nail, and we're going to get what we deserve. So I'm sorry for that little rant, brothers and sisters, but it kind of pisses me off when we don't fight for our rights. That's something that we've gotten into a bad habit of doing, of compromising when we shouldn't be. Our carriers deserve their guaranteed rights under the national agreement, and we're going to fight to get those rights for you. So thank you for joining me on this holiday edition of the Lion's Den. I'm sorry if I rambled a little bit here for you, but we will see you again soon in the new year, and 2026 is going to be a great year for us, brothers and sisters. It's going to be a year to remember, so stay tuned and stay fighting.